Thank you, ma'am. Mr. Knowlton? Okay. Nelson?
My father was a trial lawyer and trial judge for 50 years, and 3 things he told me never to do was he said, don't do domestic work unless you're starving, never represent yourself, and never cross-examine another lawyer. And here I am. I'm gonna dive in here anyways. Mr. Babcock, as part of you reviewing the matters in this case and preparing your testimony and all for today, did you review Federal Court Judge Seymour's March 29, 2017 order?
Yes, I reviewed her. I think I reviewed all the orders in the case, and there were in particular 2 orders by Judge Seymour. And I think one was March of 2017, and maybe one was March of 2018, if I recall.
I'm going to go ahead and hand you. Well, I'm going to go ahead and hand you both of them. I guess.
Okay.
I got both of them right here.
Thank you.
Did you read? There's 2 passages that I want you to read on that 2017 order. The first one, there's going to be page 14, and I should have highlighted that portion for you on that.
Highlighted portion starts with second.
Yes, sir. You go ahead and please read that for the commission.
All right, this is in the middle of a paragraph, but second, while there is more than one party required to connect the I-20 plant to the regional system, the harm is still traceable to defendant. The permit puts the onus on defendant to provide a satisfactory agreement for PSC's approval. The prior denials demonstrate what PSC will find acceptable in a proposed agreement. Further, defendant has the obligation to contract with town or take other measures to fulfill the permit requirements. Defendant has kept its plant open for 17 years after it was required to connect. While regional connection does require other actors' assistance and approval, defendant cannot be rewarded for its lack of a good faith effort to engage in negotiations and receive the required approvals. The court finds the independent actor's behavior is sufficiently predictable. The court finds the plaintiff's injury is traceable to defendant's act.
Thank you, sir. Now, there's another passage on page 28, but just based on this passage even alone, isn't it true that the federal judge found that it was not entirely the town of Lexington's fault that CWS had not interconnected with the town?
Well, I think the words speak for themselves, but I think you have a situation where I don't know how you require one party, in this case CWS, to enter into a contract. It's got to be a two-way street, and the record that I've seen shows repeated efforts by CWS to do just that.
But as far as a legal liability for doing the interconnection, as far as federal judges ruled, it is the liability or the responsibility of the company to arrange somehow for the interconnection.
That's what she found in this order, but I still don't know how you have a one-sided forced contract. You can't do that.
Let me ask you one more thing then. The other order that I've got here, which is the 2018 order. Could you please go to page 10? I don't have it highlighted on there. I apologize. If you want to, again, you could read the whole paragraph if you want to, but would you at least read the passage that begins on page 10, subsection I, nevertheless, and read that for the commission?
All right, again, you're picking up mid-paragraph.
If you prefer, sir, you can go ahead and read the whole paragraph.
Well, I think it would be better to read the whole paragraph just because that gives you better context.
Let's do that, yes, sir.
This is under a heading called penalties. Regarding the fines imposed, defendant contends that it was denied due process because the specific issue of the amount of a penalty was not briefed or argued by the parties. The Clean Water Act is a strict liability statute. Once the court found liability, it could assess a penalty in accordance with the factors found at 33 U.S.C. Section 1319, C. Stoddard versus Western Carolina Regional Sewer Authority, 784 F. 2nd, 1200, 1208, 4th Circuit, 1986, holding that upon finding a violation, the court must issue a penalty. However, the amount of the penalty is discretionary with the court. Nevertheless, in the interest of justice and because the parties essentially agreed at the summary judgment hearing that discovery and argument on the fine amount would be appropriate, the court vacates the $1,500,000 amount and will hold a hearing on the appropriate penalty for violation of the NPDES permit. The court declines to vacate the fine for the effluent limitation violation.
So what the judge has said essentially, and tell me if I'm right here, has said is that they are still going to have a hearing to determine the amount of the penalty. Is that correct?
Well, yes, but what's even more significant here is that she's saying that despite the fact that the parties had agreed that they wouldn't get into the penalty issue earlier, she had on her own done that without briefing and without argument. And one of the critical things whenever, and to me it's astounding, I guess I better be careful here, a $1,500,000 fine would be levied without having briefing and argument, because for your benefits, when you have a motion in state or federal court, almost always in state court, most of the time in federal court, what you have is a briefing on the motion where the parties submit their legal positions in terms of why they think they should win. And then oral argument, where you come before the judge, you make your argument, and then you answer his or her questions about your position. And that's the only way it really gets framed, because in a legal issue, and the whole idea behind our system is to have each side with good representation making their arguments so that either a judge or a jury can decide. But unless you've had the opportunity to brief it and argue it, you haven't been heard. And I don't know how the judge could have issued the $1.5 million fine without having that. So she's saying she's going to vacate it, and she did, took it away. Now there's going to be a future discussion on the point after the parties have the right to brief and argue, because that's the only way you can do it.
So the amount of the fine is still to be determined, correct? Or penalty is it?
I would say whether an amount would still be up in question.
And the whether an amount, it could be the $1.5 million again, or it could be more, or it could be less, or nothing, I guess, right?
You're just picking up numbers. I mean,
yeah.
The number would be whatever the judge decided, 0 or something else.
It'd be the number that she did before, or something less or more.
It could be any kind of a number. We don't know. What we do know is the 1.5 came without any briefing or argument, so that number to me is suspect because she didn't have briefing or argument.
And that's why she's withdrawn it then, and now we still have another phase to go, I guess, in this.
The parties, she realized the parties had both agreed that that was not to be before her at that point in time.
Thank you, sir. Appreciate it.
Commissioners. Commissioner Howard.
Babcock, I enjoyed your presentation, and I hope you can say the same after mine when I get through. The issue I have in rate case for legal fees is the customer has no say-so. The customers of CSS could care less whether they pay a $200 lawyer or a $500 lawyer. So what, as a customer, what right do I have as a customer, or we have as a commissioner? In other words, I feel like there ought to be some guidelines. And the guidelines could be the amount of hours they ought to spend on a case. Now, whether CWS wants to pay $500 an hour or $200 an hour is fine. But I just don't think, I got a problem with putting $400 lawyers in rate base and customers pay for it. Because you're doing it, you got the lawyer out there so you can get your rates at a higher rate for the customer. So consequently, then, the customer's getting sort of, banged over twice. And then the other thing I got is these companies, most companies have outside counsel. So I'm looking at outside counsel sitting at a table with expert witnesses, expert lawyers at $400 an hour, knowing it's going into rate base, knowing the customer's got to pay for it. What can we as commissioners do to make sure that the customers get a fair treatment when it comes to legal expense in a rate case?
Well, and let me answer that question this way. I'm not a PSC lawyer, and I haven't had to sit where you have to sit. It's a tremendous responsibility that I know you all have. But from a legal perspective, what this company did is what it had.
Microphone in front.
Oh, I'm sorry. What this company did is what it had to do because it got sued. I think if we were looking at a situation where it had initiated the litigation, then you got to have a different set of questions to be answered. But when they got sued, and the whole case starts with the Riverkeeper suing, and then you have DHEC with its permit change. So these are all things that were beyond the company's capability. And which lawyers to use? Well, the reason most companies get outside counsel, and this is true not just here, it's true everywhere. Most companies do not have inside counsel who are trial and appellate lawyers. They do other things. They may do transactions, they may do contracts, they may do a lot of other things. So what companies like CWS have to do is to get outside counsel to do their trial and appellate work. In this case, and let me back off on one point. I think most lawyers would agree that a lawyer that charges $400 an hour is likely of a different caliber than a lawyer that charges $200 an hour. There's a reason that the hourly rates for better lawyers are higher. So when you talk about $400 an hour for a lawyer, you're talking about a better lawyer, and under Mr. Tisdale's analysis, a more experienced lawyer than the young, inexperienced lawyer for the lesser rate. It's not every lawyer is the same. So lawyers who are better at what they do command a higher hourly fee. Again, here, they kept their rates arbitrarily low, and they would have been consistent with a much lower experienced lawyer than either Mr. Hafer or Mr. Lowell. So what the company did here was very prudent, and they're doing their best to benefit the ratepayers because they're trying to provide the services. Again, they were faced with a situation where they couldn't comply with the permit because they couldn't force interconnection. They could only either sell the station or stop servicing. And if they stop servicing, the people who they are servicing don't get that. They get stopped, and that would be wrong.
Well, that's sort of the point I'm making. I, as a ratepayer, could care less whether they're paying $400 for a lawyer. I guess my question is, how do I know, for example, that Mr. Hafer billed for 700 hours? How do I know that that's a fair amount sitting here? How do I know? I can justify in my mind that, okay, he's $400 an hour versus, Joe Blow, who's $200 an hour. But knowing this is going back to the customer's got to pay. The ratepayers have to pay for these legal fees. And I just got a problem with not having any guidelines. And I don't know who would furnish the guidelines, how long it would take or what's a fair amount of hours to bill for a particular case.
Okay, and let me answer it this way. The Supreme Court did that by establishing the 8 factors that were to be utilized, that this commission said were to be utilized. So the Supreme Court has done that. Now, in terms of how many hours something takes, that's very case reactive. And you can't say, well, they only should have done 100 hours and they did 200 hours. All we can say is that we know that the lawyer's bills were very itemized. You can see where the time was spent. And all of it, from my standpoint, was appropriate. There wasn't anything inappropriate that was done. Again, they were forced into litigation.
I understand that. And I guess I don't have a problem with it. I don't like the fact that still maybe it's the rate-making situation that bothers me more than anything else, that a client has to pay for a better lawyer so the customer can get a better rate to charge them. That's by and large where I'm coming from.
Well, from my standpoint, you always want a better lawyer representing you.
I'm sure you do. I'm sure that's your standpoint, and I'm not saying it's a bad standpoint. But for me, looking at a ratepayer situation, I really could care less if you're a good lawyer or a bad lawyer. Just get it done.
It's going to cost time and money for that to get done.
I know it. Thank you very much.
Thank you, sir.
Commissioner Elam.
Good afternoon, Mr. Babcock.
Good afternoon.
Following up along those lines, a circuit court judge, when he's presented with, a request for fees like this, takes these factors into account, right?
Yes, sir. Well, the similar factors in Glasscock and Speed,
right.
But yes.
And a circuit judge can decide for him or herself what they think is a fair rate and a fair amount of hours for a particular case. It's in pretty decent amount of discretion for a judge on that, isn't there?
The judge has discretion in terms of analyzing what was done and how it was done. Yes, sir.
Okay. Looking at your pre-file testimony, I want to look initially at page 5. And a sentence that starts in the middle of line 14, talking about the paperwork that you've seen about the aggressive defense by attorneys for Carolina Water that caused Judge Seymour to vacate the $1.5 million penalty, and that you say you can't overemphasize the significance of the elimination of that penalty. You see that?
Yes, sir.
What is the significance of the elimination of that penalty?
That you no longer have a $1.5 million penalty, because if it hadn't been vacated, it would still be on them.
From a ratepayer standpoint, what is the significance of eliminating that penalty?
Well, again, I'm not sure I can address it from the ratepayer standpoint, other than to say if they had the $1.5 million penalty, that might be a matter that would need to be considered by this commission and looking for the rates, because they would have had the penalty put on them. It's got to go somewhere.
Okay. Thank you. Nothing further.
Any other questions, commissioners? Hey,
I have one question.
Commissioner Urban.
Thank you, sir. Mr. Babcock, it's good to see you.
Good to see you, sir.
I wondered if you mentioned that they were sued, the company was sued, and they had to respond. With one exception, didn't they bring an action against the EPA in federal court?
Yes, sir. That was an action they did initiate, but it wouldn't have been necessary if you weren't for the river case. This was what I would call kind of an attack on the side to try to make something happen, but they did initiate that one. Yes, sir.
Wasn't that kind of a long shot in a sense of trying to get the EPA to overturn their own rules and regulations as to how the plan was set up? Wasn't that kind of to call a Hail Mary?
Judge, I wouldn't go quite to Hail Mary, but yes, it was not one that would have had a great confidence level when you brought. But particularly when we see where Judge Seymour was going, to try to have some other attack, to try to make something happen, I think was definitely worthwhile. And if you look at the actual numbers for that lawsuit, that was significantly less than certainly the other lawsuits.
But not a good result was obtained.
Didn't win.
Didn't win. That's the only question I have. Thank you.
Thank you, sir.
Thanks, Commissioner. Anyone else? Hey, Mr. Elliott, any redirect? Thank you. All right. We'll let you step down, Mr. Babcock.
May I be excused?
Yes.
Thank you, sir.
And we'll excuse that thing, too. Okay, Mr. Terraney. Sure.
To resolve some of the issues before the commission, if it pleases the commission, CWS would be willing to place the condemnation portion of the attorney's fees in a regulatory deferral account to be carried without carrying costs until the next rate case when the results of that condemnation action are known. I've conferred with Mr. Nelson. I understand the ORS does not object to that treatment. I haven't had a chance to speak with Mr. Knowlton and Ms. Valtorta about it, but it wasn't really the issue they were contesting. So,
Okay.
and that would involve no finding one way or the other from the commission.
Okay, then that's agreed. Does that complete your case? Thank you. All right. Ms. Valtorta, you will bring your witness.
Mr. Dixon, have you caused to be filed 4 pages of testimony that you and I composed?
Yes,
And have you had a chance to read over this testimony?
I have.
Do you have any changes to this testimony, or are your points the same now as when we wrote this?
Actually, I do have one change to it.
Mm-hmm.
On the second page, where we state, in my opinion, as an engineer, the entire wastewater system needs to be overhauled in the neighborhood. After looking at the rebuttal testimony and listening to Mr. Laird, I agree with the design he's looking at, and I feel that if it's properly maintained, it would be an acceptable solution for the neighborhood.
Okay. I would move then to admit this pre-filed testimony with that change noted. Yes.
Okay, we will move into Mr. J. Dixon's pre-filed direct testimony with the changes that he just stated into the record as if given orally from the stand.
Mr. Dixon, you're one of the houses that's been experiencing this wastewater backup. Is that correct?
That's correct. I'm one of the 3 houses that has been discussed.
Okay. And you do some engineering work yourself. Is that true?
That is correct.
What is your job?
I am the president of a company called TechSheen Incorporated. We do industrial wastewater and laundry systems. I'm also vice president of a company called American Water Purification, and on their board as directors as well.
So does that involve work with wastewater removal at all?
Yeah, we primarily will build water treatment facilities in industrial applications for the reuse purposes of water.
Okay. Now, you said that you had read Mr. Keith Laird's testimony recently. Is that true?
That's correct.
And he also had some communication with the neighborhood. Is that correct?
Yes, they've been quite active in the neighborhood, pretty much since I guess you got involved in the matter, working through the commission here. And they've been pretty communicative with us, and we've been working with them trying to come up with a solution that's going to work for us.
Okay, so as you understand this solution as it's outlined, both at your house and for the entire neighborhood, do you think that that's a good solution for now?
Yeah, I do, if they're fully implemented.
Okay, and do you have some concerns that the plan to upgrade the wastewater removal system at 40 Love might not be carried out?
I do. If you go back in the history of this exercise, this all started, at least I recognized it, Christmas Eve of 2014. So for the first 3.5 years, I kind of felt like I was beating my head against the wall trying to get someone to listen to us and address our concerns. Until I guess I had a meeting at my office with DHEC, the LRC, utilities, and some of their contractors to try to get something started. There was a little bit of movement, but quite frankly, until you were involved and was brought in front of the commission, we really didn't see a lot of tangible efforts made.
But now you see some work being done at your house. Is that true?
We're on the cusp of it, yes. They've been in the neighborhood quite frequently here recently. At my individual house, they've had locate services, and I think the plan is to try to get our individual houses addressed here in the next week.
Okay. Do you see the need for a supplemental hearing or reporting to the commission on this problem?
Yes, I would really appreciate something like that, just to keep some awareness and make sure we're moving forward. If you look at the timeline, for the individual houses, that should really be addressed here in the next couple of weeks. My concern of that is the issue is a neighborhood-wide issue. So if our 3 houses are addressed and nothing else happens, the issue is going to occur at the next lowest houses in the neighborhood at some point. And the timeline is for implementation of the neighborhood-wide solution in January sometime. But it's been my experience that we've had lots of talk and no action. And this has been the forum that's brought action for us.
Okay. And your house is pretty low-lying with respect. You're close to the lake, is that right?
Correct.
And there are many other houses in the neighborhood that are low and close to the lake. Is that true? Yeah,
it's primarily been the houses that have basements that are on the lake water or the lakeside that had the issues. You could get in a boat and kind of go around the cove in our neighborhood and pick the houses out that likely have problems. But quite frankly, we're 4 years into this partly because I didn't want to come forward and say, hey, I've got a problem in my house. I can't get Carolina Water to fix my problem. I can't sell my house because you have to disclose you've had sewer issues until it's repaired. So I'm kind of in a catch-22, and I feel certain there are other people that don't want to expose themselves to the possibility of, hey, I have a house with a problem.
Okay. So if you feel we should have a supplemental hearing in short about the progress of this.
Yes, I would like to see a supplemental hearing sometime in the beginning of the year so that we can see if the progress has truly been made to the timeline that's been stated.
It wouldn't take very long, would it?
I could just stand up here and say it's done.
Okay. That's all I have.
Thank you. Mr. Knowlton, any questions? Okay. Mr. Nelson. Okay. Company. Mr. Trainee. Mr. Elliott. Commissioner Elam.
Thank you. Good afternoon, Mr. Dixon. If you have neighbors who are unwilling to come forward, if we had a hearing early next year, how will we know if it's fixed?
In my opinion, as an engineer and as someone who kind of deals in this a little bit, if the design that has been proposed for the neighborhood-wide solution, so there's 2 basic solutions being offered. One for the 3 houses that are having a problem immediately. Once those 3 houses are solved, we're going to kind of fly off the radar. We shouldn't really have any issues going forward. But if nothing is done, there will be other houses at some point that will have an issue.
Your next door neighbor
could very well be having a problem, and they don't want to say a thing about it.
And the house after that.
They likely have a problem also.
And the house across the street from that.
No, they'd be fine. They're uphill.
Okay.
The proposed neighborhood solution basically will alleviate the pressure on the system when we have rain. It's a rain situation. And so what's being proposed is actually put a second pumping station of sorts to alleviate the pressure on the overall system. A LET system is a horrible design, and it's, I'm sure one will not get approved now, but it's what we have and it's what we're having to deal with. And what I'd love to see is, I'd love to see a traditional sewage system like every other neighborhood has, and I understand the cost of that. So the proposed solution to me is workable solution as long as it's maintained.
Do you, based on your experience, do you believe the company's doing everything it can with inflow and infiltration?
It's one of the solutions that was proposed back when we had the meeting in my office. They were going to go through and smoke all the houses in the neighborhood and see if there was anyone tied in or any issues like that. It was started and stopped because of customer complaints. People were having, didn't want people in their yards. It's one of those cases where if it's not in my backyard, I'm not going to worry about it. And so, I think it's an ongoing issue. They've been addressing it. They've gone and done surveys. Is it solved? No. Will it be 100% solved? I doubt it. It's the reality of it is it's pipes underground. Something's going to go wrong.
So is the neighborhood-wide solution that you're talking about, do you believe that's going to solve everyone's problem without further addressing the I&I issues, or no?
I haven't looked at the engineering design of it, but you could certainly engineer around that problem. The reality of it is it's a 40-year-old system that's, you have I can't remember if it's a 6 or 8 inch main going around the perimeter of the lake. So there's been lots of times that I'm sure roots have tried to get in there, pipes have been broken, things like that. And that goes to the maintenance of it. I mean, if there's an ongoing maintenance problem or maintenance program that addresses it and looks at inspects and does things like that, then I feel it can work.
Okay, thank you.
Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. Dixon, thank you for being with us, and thank you for being willing to testify. You just testified with your attorney, Ms. Valtorta, that this was the only forum that you've seen progress, been able to get something done. Why would your neighbors not be willing to come forward?
You don't want to be the person that has a sewage problem in your house.
Well, you think the fact that are they trying to sell their home and don't want to bring attention to it?
Absolutely. I mean, you have for most people, homes are the biggest single investment they have. So when you want to stand up and say, hey, I've got a problem with my house, you then have to disclose those things in the future, and it becomes a liability to them. I'm hoping through all of this, I get a resolution where I can tell people I had an issue, it's fully solved, there's nothing to worry about.
And you understand that of course, the laws that we're under up here as a commission, that's the only way we're going to hear about it or know about it. And it could be the company's not subject to the laws and judicial code that the commissioners are, and neither is ORS. But could be that folks like the company or ORS that are in a position to help them before it even gets to this format may not even know.
I understand. I mean, if it goes back 4 years. I spent Christmas Eve 4 years ago with a trouble man from the water company or Carolina Water, trying to figure out why I've got sewage coming up at my house. The same evening, a cap came off the system and it got water into Lake Murray, or wastewater. So we had to have notices put around the neighborhood. In that period of time, 2 months later, I began complaining, and I got to the point where I was waking up when I knew it was going to be raining about 5 a.m. so I could call Utilities Incorporated, who's the parent company, and tell them that, hey, I've got a problem in my house. Get out here, start pumping so I can take a shower. At the same time, I was sending emails out to the neighborhood saying, anybody else having problems? It was silence. It was crickets. Now, over time, people had bad enough backups that wastewater was getting into their houses. That's when we got the 2 other parties involved. I hear rumors of other neighbors, but once again, you don't want to be the guy with a house that's got sewage coming up.
Yeah. Well, Ms. Valtorta's been coming over here a long time, and this commission certainly appreciates you coming forward, and it's the only way we're going to know about it.
Yeah.
So thank you, Mr. Chairman.
Thank you, Commissioner Whitfield. Any other questions, commissioners? Any redirect, Ms. Valtorta? Yes, ma'am.
Thank you all.
Dixon, thank you for being here. You may step down and you are excused. All right, Mr. Nelson. Mr. Knowlton. Sorry. Mr. Nelson.
If I could, I would like to take our witnesses out of order from what we had previously presented, because we wanted to put up Ms. Hipp and Mr. Sullivan as a panel, but we have Mr. Bill Stangler here, who's the Congaree Riverkeeper, and if I could, I'd prefer to put him up now so that we can let him leave.
Fine.
Thank you. In that case, ORS would call its first witness Mr. Bill Stangler. Please give your full name and occupation for the commission.
My name is Bill Stangler, and I am your Congaree Riverkeeper.
Mr. Stangler, are you the same Bill Stangler who pre-filed 8 pages of sua rebuttal rehearing testimony in this case on August 29th?
I am.
Do you have any changes, edits, or corrections to your pre-filed testimony?
I do not.
Thank you. ORS would ask, Mr. Chairman, that the sua rebuttal rehearing testimony of Bill Stangler be read into the record as if given orally from the stand.
Okay, Mr. Stangler's sua rebuttal testimony will be read into the record as given orally from the stand.
Thank you, Mr. Chairman. Mr. Stangler, can you tell us what the purpose of your testimony is in this proceeding?
Yes. My purpose of my testimony is to respond to testimony given by witnesses for Carolina Water Service concerning the federal lawsuit, Congaree Riverkeeper v. Carolina Water Service.
And have you reviewed the pre-filed testimonies of CWS's witnesses in this case?
Yes, I have.
Can you tell us why the Congaree Riverkeeper filed the lawsuit against CWS?
Yes. Our Citizen Clean Water Act lawsuit against CWS was brought in an effort to bring the I-20 facility into compliance with their Clean Water Act permit. The permit had unambiguously required that the I-20 plant be connected to a regional wastewater treatment system and cease discharging into the Lower Saluda River, which is a designated state scenic river, since 1999. A decade and a half later, the discharges from the I-20 plant continued into waters where the public recreates. And there were also numerous effluent limitation violations at the I-20 plant. Our litigation sought to address both of those issues.
Does CRK regularly bring lawsuits against other entities that improperly discharge into the state's waters?
So, Congaree Riverkeeper's mission is to protect and improve water quality, wildlife habitat, and recreation on the Congaree, Broad, and Lower Saluda rivers through advocacy, education, and enforcement of environmental laws. So we monitor all sorts of sites and polluters in our watershed, and we take enforcement actions when necessary. While this was our first federal Clean Water Act lawsuit that the organization ever filed, we have sent notices of intent to sue over other sites and other polluters, and we've also resolved violations with others without the need for litigation. We would certainly file litigation for other violations of the Clean Water Act if necessary. We focused on Carolina Water Service because they were clearly violating the terms of their permit and it was having a real impact on the river, and we would certainly consider litigation against any other company doing the same thing.
Would CRK have brought the lawsuit against CWS had the company not had multiple effluent discharge violations?
So the Carolina Water Service's regular pattern of ongoing effluent violations was one of the things that brought this facility to our attention in the first place, and it was a key factor in the decision to file the lawsuit.
Were CWS's effluent discharge exceedances only a secondary component of the CRK lawsuit?
No, they were not. We brought 2 specific claims in our lawsuit. One, that CWS had routinely violated the terms of their MPDS permit with effluent violations, and that they had violated their permit by failing to connect to the regional sewer system.
In your opinion, Mr. Stangler, was the company's only liability that which arose from their inability to interconnect with the town of Lexington?
No. Carolina Water Service is also liable for a number of effluent violations, including repeated violations for fecal coliform bacteria and biochemical oxygen demand. The court's ruling demonstrates this point, as the court found that they had violated effluent limitations in their Clean Water Act permit 23 times, and that was a ruling that the court refused to reconsider at CWS's request.
Did CRK bring suit in an effort to have CWS terminate sewer service to their more than 2,000 customers?
No, we did not. We never asked for a termination of their sewer service to customers in our litigation, and in fact, when the court ruled in our favor, the court gave CWS a year to reach a resolution to avoid that sort of termination.
Did CWS violate its MPDES permit requirements by discharging untreated wastewater into the river?
Yes, they violated the limits of their MPDS permit. They discharged undertreated waste because they did not meet the limits of their permit.
And did CWS's difficulties in negotiating interconnection or the sale of its system to the town of Lexington allow CWS to violate its MPDES permit?
No, it did not. The Clean Water Act is what is called a strict liability statute. All the plaintiff needs to do is establish that the defendant violated the terms of their permit. Good faith efforts to comply or alleged impossibility is not a valid defense. Under the Clean Water Act, the party must either achieve the discharge levels they've been allowed, pay the consequences, or stop discharging.
Can you tell the commission a little bit about the court's ruling in the federal court action that you had?
Yes. In March of 2017, a federal court held that Carolina Water Service violated their Clean Water Act permit by failing to connect to the regional system for more than 15 years and by violating multiple effluent limits contained in the permit repeatedly. The court imposed a $1.5 million penalty against CWS for its violations of the connection requirement and a $23,000 penalty for violating the effluent limits.
And did the court grant CWS's reconsideration after this ruling?
So CWS filed multiple motions after the court's order, as was its practice throughout this litigation. One of their motions sought reconsideration of the court's ruling on liability and penalties. Another sought to dismiss the case as moot even after the court had ruled. Regarding reconsideration, the court largely denied their request for reconsideration, finding there was no basis to change its conclusion that CWS had violated the Clean Water Act for failing to connect to the regional system and by exceeding their effluent limitations. They did grant reconsideration on the $1.5 million penalty because the parties had agreed that we would present evidence on an appropriate penalty if they were found liable, and we had not had a chance to present such evidence. It is important to note that this penalty proceeding is still ongoing. We're going to conduct discovery on the penalty and argue an appropriate penalty by October 8th. And the court could easily impose the $1.5 million penalty, a higher penalty after reconsidering, or a higher penalty after reconsidering this evidence.
Was the fine imposed on CWS related to the improper discharges and effluent violations vacated?
No, that was not. The court explicitly refused to vacate the $23,000 penalty for the effluent limitation violations. And again, the penalty for the violation of the connection requirement was not vacated to never be reinstated. The court is now deciding what that penalty should be after briefs are filed in October.
Could CWS have avoided costly litigation with CRK had they not violated their MPDES permit and had not discharged poorly treated waste into the river?
Yes, of course. It was the pattern of ongoing effluent violations that we noticed, and then the failure to connect and eliminate the discharge by 1999 as required in the permit. CWS said that it did not have the ability to resolve the connection issue, but we disagree, and the federal court has disagreed. The federal court explained that the onus was on CWS to connect regardless of whether they could achieve the sort of connection that they wanted. The court also found that there are numerous ways to connect to the facility, and they found that connect does not mean on the defendant's terms, nor does it mean that they will have a continuing role after the connection is made. CWS certainly had the power to stop the effluent limitations that we sued them over, and they did not.
Stangler, did CWS undertake years of efforts to comply with its permit, and was it prevented from complying with the connection requirement?
I think that assertion by Carolina Water Service is misleading. This case has a very long history, but the federal court found that in 1998 they initially attempted to comply with the permit. However, they failed to undertake any attempt to comply with the permit between the years of 2002 and 2014. The long and short of it is that CWS attempted to connect on terms that were favorable to CWS, but this does not comport with the strict liability nature of the Clean Water Act. As we've noted, the effluent limitation violations were separate violations that CWS also failed to remedy. Moreover, as is required by the Clean Water Act, we provided Carolina Water Service with a 60-day notice of intent to sue letter over this facility in November 4th of 2013, and yet we did not file our lawsuit until January of 2015. CWS had time during that period to try and resolve this situation, but no resolution was reached. The idea that our litigation was impossible to avoid is wrong.
Could you please tell us what the purpose is of a CWA citizen suit?
Yeah, the citizen suit plays a key role in ensuring that dischargers do not have a license to pollute indefinitely in cases where the government agencies do not stop such pollution. That is exactly what happened here. DHEC had not been able to force CWS to comply with the Clean Water Act in their permit, and so we stepped in to do so.
Stangler, what in your opinion would be the effect of the PSCs allowing CWS to recover fees for defending against such a citizen suit?
So a Clean Water Act citizen suit is designed to result in penalties that have a deterrent effect on current and would-be polluters. The federal court has found that such penalties are appropriate, and if the PSC allows CWS to pass on its attorney's fees to its consumers, then this mitigates that deterrent effect that Congress intended with the citizen suit provision of the Clean Water Act. you have to ask yourself a question. Why would a utility ever voluntarily come into compliance if it could instead refuse to comply, litigate for years, and then recover the costs of that litigation from consumers, even if it doesn't prevail?
Mr. Stangler, does that conclude your testimony?
Yes, it does.
Thank you, sir. Mr. Stangler is available for questions from the other parties or the commissioners.
Thank you. Thank you. Ms. Valtorta. Mr. Knowlton. Thank you. Company. Mr. Hafer.
Reorient.
Mr. Hafer, you do realize that's $400 an hour. You do realize that's $400 an hour you're killing over here. Just teasing. Thank you.
Howard, I have tried by the word, but I haven't been able to get anybody.
Touche.
Yes. Thank you. Thank you, Mr. Chairman. Good afternoon, Mr. Stangler. How are you today? Not bad. How are you? I'm doing well, thank you. You state at page 1, line 2 of your pre-file testimony that you are, quote, your Congaree River keeper. Who's the your you're referring to there, Mr. Stangler?
Citizens of the Midlands who care about clean water and healthy rivers.
So is it fair to say that it's more than just the people who belong to your organization as members, or people who recreate in the river, or people who do business in the river? It's the community as a whole?
Yes.
Okay. And you've been employed as a Congaree Riverkeeper since 2011, is that correct?
Almost 7 years now.
2011 is when you became employed there. Did you come to that position straight after completing your geography degree at USC?
I was actually in grad school at USC for several years, and before finishing my master's degree, I took this job.
Okay. All right. Well, thank you. And your undergraduate year, you graduated in 2010, is that right?
2009.
2009. So anything that happened with Carolina Water Services I-20 system before 2011, you would have learned about that after the fact?
Yes, I've learned a lot about I certainly followed some issues on the rivers as I worked as a river guide and was involved in river issues at my time at USC, but I certainly learned more about Carolina Water Service 2011 on.
Okay. Page 1, line 17 of your testimony, you state that your job involves, and I'm quoting here, advocating for local rivers. Is that correct?
That is correct.
Tell me, what rivers do you consider to be within the ambit of your advocacy function?
Yes, so we work on 90 miles of rivers in the Midlands, which is the lower Saluda from Lake Murray down to the confluence, the Broad River from the Parshals Dam down to the confluence, and then the entire length of the Congaree until it merges with the Wateree River. Technically, I usually say 3 rivers, but Little River in Richland County is also a river and also is in our jurisdiction. There's also more than 2,000 tributary miles of tributaries that we also work to protect in our watershed.
So your advocacy function does include tributaries into the rivers you've identified?
Yes, it does.
Okay. Now, in connection with your duties, do you monitor discharges by utilities into those rivers and tributaries?
Yes, we do.
How do you go about conducting that monitoring?
There's a handful of ways. We review discharge monitoring reports, the permittee responsible monitoring, both through FOIA requests to DHEC and through the EPA's Enforcement and Compliance Online History ECHO database. We also collect water quality samples downstream of several wastewater discharges in the area.
So you review the ECHO database for the discharges into these rivers and the tributaries?
The ECHO database, as well as occasionally doing more thorough follow-ups with FOIA reviews at DHEC and actually getting the hard copies of the DMRs.
Okay. And I want to hand you a document and ask you if you can tell me what it is.
This appears to be a printout of a from the ECHO website with some information about the town of Lexington's Coventry Woods wastewater plant that used to discharge into 12 Mile Creek.
And is 12 Mile Creek one of the tributaries that you monitor?
It is.
And have you reviewed this ECHO report for the town of Lexington before?
I don't know when that one was done, and they update this regularly, so I have reviewed in the past compliance reports and DMRs for the Coventry Woods facility.
Okay. Now, let me ask you, Mr. Stangler, as a exhibit to the complaint that the Riverkeeper filed in federal court, you also attached a ECHO detailed facility report for the Carolina Water Service I-20 system, did you not?
I believe we may have used ECHO data to supplement. We also included the actual DMRs that we copied from DHEC.
Okay. And Mr. Chairman, I'm going to be going back and forth with Mr. Stangler quite a bit. Let me ask you if you can look at this document and tell me what that is.
This appears to be another ECHO printout for the CWS I-20 facility.
Okay. And does that document bear a legend at the top of each page?
A legend?
Does it have writing at the top of each page?
Yes, it appears to be a reference to court filing.
And is that reference to the court filing of the Congaree Riverkeeper, Inc. versus Carolina Water Service case in United States District Court?
I'm going to assume that it is.
Well,
I actually remember the numbers off the top of my head.
Did you review the complaint in the Congaree Riverkeeper case filed in federal court?
There it is. Yes, the numbers match up.
Okay, so is this a document that was filed in federal court?
Yes.
Okay. Mr. Chairman, at this time, I would like to enter into the hearing record as the next exhibits the detailed facility report of the Lexington Coventry Woods subdivision that Mr. Stangler identified. And I do have a copy for counsel. I'm sorry.
Okay, we will enter it as exhibit number what? Okay. Oh, that's quite all right, Mr. Nelson. I'd like to let you review that. Mr. Hafer, do you
I do intend to establish the relevance of the
establish the
document.
relevance? Okay. So we will admit it. We'll admit it as exhibit number 9.
And as the next hearing exhibit, Mr. Chairman, I would offer the exhibit Mr. Stangler just identified as being attached to the complaint in the federal court case, which is the ECHO detailed facility report for the CWS I-20 regional system.
Mr. Chairman, could I ask Mr. Hafer a question? May I?
Sure.
Mr. Hafer, how are you, sir?
I'm doing fine, Your Honor. How are you?
I'm great. I know you're very thorough in your presentation, and we appreciate that, but I hope you're not going to make us retry the federal case today.
Well, Your Honor, I am going to demonstrate the relevance of these documents that I
Could
just
you give us a hint about what that might be, since this has already been litigated in the federal court?
Well, in fact, the town of Lexington's ECHO filing has not been litigated in federal court.
Thank you.
But the relevance is this witness has testified that the company was in violation of a permit, that his function is monitoring the conduct of permitted dischargers, and that the attorney's fees and expenses in this case were unnecessary. I think we're entitled to lay out
Thank you.
all of that. Thank you. So, Mr. Stangler.
Hang on for 1 second. Let me ask Mr. Nelson. Okay. So we'll enter that as exhibit number 10.
Mr. Stangler, let me ask you to go back to first the exhibit that's been entered into evidence, consisting of the exhibit to your complaint in federal court, or the Congaree River complaint in federal court, and ask you to look at that. All right, sir. That shows 10 permit limit exceedances occurring in 8 of 13 quarters during the period October 1, 2011 and ending December 31, 2014. Does it not?
I see 8 of 12 right here in the enforcement compliance summary.
Well, if you would, go to page 4 or 5 of that document, Mr. Stangler.
Four or 5.
Page 4 of 5.
Okay.
And you see the section entitled 3-year compliance status by quarter?
Yes.
And how many quarters are listed across the page there?
Uh, 13.
Okay. And during that 13-quarter period, how many permit exceedances do you count for the Carolina Water Service I-20 system?
You have an unknown. You have 1, 2, 3, 4, 5, 6, 7, 8 with violations, 3 with no violations, and 1. I actually don't know what the UND, I think it might mean undetermined.
I'm not asking about the facility level status. I'm asking about the specific exceedances. If you will look below that in the chart.
So something important to point out about the way that ECHO works, what you're looking at is a single exceedance is listed on here, not all of them. So you actually have to break down you have to go a lot deeper into ECHO to get the individual non-compliance pieces. So this is a summary that doesn't even show all the violations, but I see 1, 2, 3, 4. I see 10 quarters where there were violations for different parameters.
Okay. And do you also see in this report in the section Informal Enforcement Actions 5 years, do you see that Carolina Water Service received 8 violation letters or warning letters?
Yes, I see a number of notice of violation letters.
Okay. And the violations that are shown in this ECHO detailed facility report, they were part of the basis for your lawsuit, correct?
Yes.
Now, let me ask you to go to the detailed facility report for the town of Lexington. It's been entered into evidence. Do you have that document, sir?
I do.
And if you would, go to page 3 of 5. And look at the section 3-year compliance status by quarter.
Mm-hmm.
You have that?
Yes.
And doesn't that show that in the 8 quarters, in 8 of the quarters during the period April 1, 2012 through June 30, 2015, the town was in violation of its fluid limits under its NPDES permit?
Yes, it was.
And there were a total of 16 permit limit exceedances, were there not?
Actually, I can't speak to the total number because this is a summary chart that doesn't show individual violations, as I mentioned.
Sure. Just shown on this chart, there's 16.
There
Is that correct?
there are 16 instances where there was a violation within a quarter for a certain parameter.
And given your familiarity with the ECHO and the detailed facility report, you know what the abbreviation SNC stands for, do you not?
Significant noncompliance.
And how many instances were there significant noncompliance by the town of Lexington during that 13-quarter period?
This chart shows 4 quarters where there were significant noncompliance violations for 2 different parameters.
Okay, and isn't it correct that the detailed facility report for the I-20 system that was attached to your complaint in federal court showed no significant noncompliances, did it?
Yes, the CWS I-20 report did not have what the EPA calls SNC violations.
Significant noncompliance, correct?
Yes.
Go to the next page of that exhibit that you're looking at, page 4 or 5, under informal enforcement actions. And tell me, am I not correct that from the period of April 23rd, 2010 to August 8, 2014, that the town of Lexington received 11 letters of violation or warning letters?
That is what this printout shows.
Okay, thank you. You state at page 12, let's go back to your testimony, Mr. Stangler, if we could. You state at page 2, lines 1 through 3, that the purpose of your testimony, and I'm quoting here, is to respond to testimony given by witnesses for Carolina Water Service concerning the U.S. District Court case captioned Congaree Riverkeeper, Inc. versus Carolina Water Service, Inc., Civil Action Number 3:15 CV 00194-MBS. Is that correct?
Yes.
Before we get into talking about that federal court action, I want to ask you this question. To which Carolina Water Service witnesses' testimonies are you responding to?
I reviewed testimony from Mr. Babcock and also Mr. Gilroy.
Okay. And you're responding to all parts of both of those testimonies?
No, I don't believe I'm responding to every part of their testimony.
Okay. Was there some part you're not responding to?
I'm unclear on the question. Can you rephrase it?
Well, I'm asking you which parts of Mr. Gilroy's and Mr. Babcock's testimonies are you responding to?
Generally the portions that discussed our litigation.
Okay. You indicate that the citizen suit brought against Carolina Water Service by the Congaree Riverkeeper was the first one Congaree Riverkeeper, Inc. ever brought?
Yes.
Okay. Prior to that federal court action, had you had any experience in dealing with attorneys in litigation matters?
Had I personally or had the organization?
Well, we'll start with you personally.
Yes, I've dealt with attorneys in litigation matters before, but I've never been a participant in a citizen or environmental lawsuit.
Okay. And in your dealings with attorneys in litigation matters prior to the filing of this lawsuit, tell me what those experiences involved.
General conversations with attorneys, environmental attorneys. Are you specifically talking about environmental litigation work?
No, I'm asking about you personally as a human being. Have you dealt with attorneys in litigation matters prior to the Congress?
Yeah, I did have an underage drinking ticket when I was in college.
Well, that's not what I was.
Well,
I'm sorry, that's not what I was driving at. But let me ask you this question: is it fair to say you've been deeply involved in this Congaree Riverkeeper versus Carolina Water Service case?
Yes.
Has there been anyone at Congaree Riverkeeper, Inc. that's been more involved in that federal court action than you?
Until about 8 months ago or 7 months ago, I was the only staff person for the organization. Okay. So, no, I've been the most involved staff person for the organization.
Do you recall Mr. Stangler giving a presentation to the Leadership Columbia class for the Columbia Chamber of Commerce on May 5, 2015?
I do not remember that specific presentation. I give a lot of presentations to a lot of groups.
Have you appeared in front of a Leadership Columbia class?
I have in the past, yes.
Okay. Do you recall in that presentation telling the Leadership Columbia class that the filing of the citizen suit in federal court was one of the achievements you were most proud of in your career?
I do not recall that specifically, but I won't deny it.
Okay. Does it sound like something you might have said?
Certainly.
Okay. Would you have less pride in that achievement if the federal court or a federal court determined that Carolina Water Service was not obligated to pay any penalty?
I don't know that that would be the case.
Okay. Did you also state to the Leadership Columbia class that the Southern Environmental Law Center was representing the Congaree Riverkeeper for free in this federal court litigation?
I believe I occasionally referenced pro bono representation from SCLC. So it's certainly possible that in a presentation I gave in 2015, I mentioned that.
Okay. You indicated, go to page 5 of your testimony, if you would, lines 6 through 13.
Okay.
You have it? You indicate there that CWS filed multiple motions in this litigation, correct?
Yes.
And that the Congaree Riverkeeper, and I'm going to quote here, spent huge amounts of time dealing with all of CWS's motions in this litigation. Is that correct?
Yes.
Do I understand incorrectly that you personally have spent a huge amount of time on CRK's responses to these motions?
I think that is a reference to the effort and time put in by both Southern Environmental Law Center and myself and my organization.
So your answer to my question is yes, you have spent a huge
Yes,
amount.
I have spent a significant amount of time.
Okay. Am I correct in understanding that you've reviewed all the pleadings, the motions, the motion exhibits, the affidavits, the orders, the discovery requests, the discovery responses, and the documents produced and other papers filed in that federal court action?
I have reviewed many. I won't say that I've reviewed every document in this case. I do depend on my attorneys to do a good bit of that work as well.
Okay. Can you tell us which documents you think you might not have reviewed?
Now, that seems like a very difficult question to answer.
Are you suffering from a lapse of memory, or you just don't know?
To tell you the documents that I haven't seen,
Microphone.
Asked and answered, and also I think Mr. Hafer is just being abusive of the witness, and I'd ask him to stop.
Okay, let's just move on.
Thank you, Mr. Chairman. Well, let me ask you this, Mr. Stangler. Were you present in federal court for the arguments of counsel on the motions for summary judgment that were filed by Congaree Riverkeeper and Carolina Water Service in this federal case?
yes, I was.
Okay. And did Mr. Holman, Mr. James Blanding Holman IV, did he not represent Congaree Riverkeeper and make that oral argument?
Yes, Bland was one of the attorneys that represented us.
And did he argue that motion?
Yes.
Okay. Let's go back to your testimony, page 2, lines 8 through 9. You there?
Yes.
And there you state, I believe, and I'm quoting, you state Congaree Riverkeeper brought the federal action against CWS, and now I'm quoting, in an effort to bring the I-20 facility into compliance with their Federal Clean Water Act permit. Is that correct?
Yes.
Tell me, by the phrase Federal Clean Water Act permit, do you mean the National Pollutant Discharge Elimination System permit number SC 0035564 issued to Carolina Water Service?
I do mean the NPDS permit for the CWS I-20 wastewater plant.
Okay, and that permit was issued on November 17th, 1994. Is that correct?
I believe that is correct.
And it was expired on September 30th, 1999. Is that correct?
That sounds correct.
Okay. I want to show you a document and ask you if you can identify this for me, please, sir.
This appears to be a copy of the 1995 NPDS permit for the I-20 wastewater plant.
And does the document bear the federal court legend at the top that I asked you about earlier?
Yes, it does.
And it was this filed in federal court?
Yes, it appears to be.
Mr. Chairman, I would move as the next hearing exhibit the November 17th, 1994 surface water discharge permit to Carolina Water Service. It bears the federal court entry number 1-1.
Mr. Nelson. The exhibit number 11.
Mr. Stangler, did the Congaree River Keepers lawsuit result in Carolina Water Service bringing the I-20 facility into compliance with the NPDES permit that was just entered into the record?
I believe the lawsuit resulted in the end of the issues that we had with the I-20 facility and eventually ended with the elimination of the discharge, and there are no longer any ongoing violations, effluent violations from the facility.
Well, at the risk of being accused of being abusive by Mr. Nelson again, I'll ask you to answer the question I asked. Did the Congaree River Keepers lawsuit result in Carolina Water Service bringing the I-20 facility into compliance with that NPDES permit?
I believe it did.
Okay, and how is that?
Because one of the requirements of that permit was the elimination of that discharge, and I believe that lawsuit was the impetus for that final result.
And when did the discharge end, Mr. Stangler?
I believe it was February 28th, approximately 1:15 p.m.
And who owned the I-20 system on February 28th?
The town of Lexington.
Okay, and when did the town of Lexington take the I-20 system?
I don't actually remember the exact date where they initiated condemnation and took ownership. I believe it was earlier that year.
Okay, and isn't it true that that permit that was just entered into evidence was transferred by DHEC from Carolina Water Service to the town of Lexington?
Along with the rest of the property that they condemned. They also got the permit.
Did DHEC transfer the permit from Carolina Water Service to the town of Lexington?
I believe they did.
Okay. So at the time the discharge was eliminated, Carolina Water Service didn't own the system and didn't hold the permit, did they?
No.
Thank you. Now, isn't it also true that the town of Lexington operated the I-20 system for a month before they eliminated that discharge?
I believe that is correct.
Okay. So Carolina Water Service never connected the I-20 system to the town's regional facility, did it?
I guess you are correct that CWS never did come into compliance with the permit.
Okay. Now, let me ask you this. How did you come to pre-file testimony in this case?
ORS reached out and asked if we'd be willing to testify.
And who from ORS called you?
I believe they reached out to the attorneys that worked on this case with the Southern Environmental Law Center, and then I was contacted by our attorneys.
Okay, so you did not have an initial contact with ORS. It was your lawyers that had initial contact with ORS. Is that correct?
Yes, that is correct.
And your testimony is that the ORS lawyers contacted the Congaree Riverkeeper, Inc. lawyers in the federal court case?
To the best of my knowledge.
Okay, all right. And after that contact, did you meet with people from ORS?
Yes.
Okay, when did you meet with them?
We had a phone conversation, and I met at their office last week.
Okay, when was the first contact that you had? Was it a phone conversation?
The first contact was a phone conversation, and I don't know the exact date. I believe it was within the last 2 weeks.
Okay.
Object to this continued line of questioning for relevance. I don't understand how we got Mr. Stangler over here to testify has to do with anything in this case.
Your Honor, it is cross-examination. There hasn't been any discovery. I think I'm entitled to the latitude to find out how Mr. Stangler, otherwise a disinterested person, came to testify in this case about legal fees incurred by Carolina Water Service, which are at issue in this case.
Okay. All right. It's being discretionary. We're going to give you some latitude there.
Thank you, Your Honor. Now, Mr. Stangler, let's go back to your testimony, page 2 of your testimony.
Okay.
Starting on line 9. The permit you're referencing there, you say this permit had unambiguously required the I-20 plant be connected. You see that?
Yes.
And that permit is the Carolina Water Service I-20 NPDES permit that's been entered into the record?
Yes.
Okay. And you say this permit had unambiguously required that the I-20 plant be connected to a regional wastewater system, regional wastewater treatment system, and cease discharging into the lower Saluda River a state scenic river since 1999.
Yes.
And you go on to say that, a quote, a decade and a half later, CWS's discharges from the I-20 plant continued into the waters where the public recreates. Is that right?
Yes.
Okay. You're aware, are you not, that CWS's position in the federal court case was that there was no connection available to it from the town of Lexington?
I have heard that, yes.
And you are also aware that CWS's position was that a connection involved just that, a connection of the I-20 system owned by CWS to the town's regional line?
Yes, I'm aware that was the contention.
You've referenced the federal court order a number of times in your testimony, correct?
Yes.
And specifically at page 5 of your testimony, lines 1 through 3, if you could go there.
Yes.
Is that the federal court order that you're talking about? The one issued in March of 2017?
Yes.
Okay. Do you have a copy of that federal court order?
Not in front of me. I believe one can be provided.
It's been entered into evidence. You've seen the federal court order, have you not?
I have.
Okay. All right. Well, for ease of reference, without having to bother the court reporter. If you would, go to page 25 of that order, Mr. Stangler.
All right.
And if you would, go to the top of the page, beginning with the word "the" in the first paragraph.
The order reads, the terms in question are connect and available. The court finds that both connect and available are ambiguous terms with reasonable interpretations by both parties. Therefore, the court will look at extrinsic evidence to determine the meaning of the terms. Additionally, the court considers the permit in regard to the Clean Water Act's purpose, which is to eliminate discharges from the nation's waterways. And there's a citation.
Mr. Stangler, the federal court said that the permit was ambiguous, didn't it?
That is what this reads right here.
But yet you've testified that the permit unambiguously required connection, haven't you?
Yes.
Okay. Are you aware of whether any other courts or administrative agencies have interpreted this permit in the same manner that the Congaree Riverkeeper interprets it?
I'm not aware of that.
Okay. Are you aware of any other courts or agencies that have interpreted it in the manner that Carolina Water Service interprets it?
I'm not aware of that either.
Okay. Well, let me ask you, and I understand that you reviewed some and didn't review others, but let me ask you, if I could, to look at this document and tell me if you can identify it.
This appears to be the Administrative Law Court final order for a Carolina Water Service v. South Carolina DHEC case from 2002.
And you were in the hearing room earlier when Mr. Gilroy testified on behalf of Carolina Water Service.
Yes.
Did you hear his testimony mentioning this order?
I did not.
You did not. Okay. And are you aware that in this 2002 order, the Administrative Law Court found that Carolina Water Service could not be penalized for not having connected the I-20 system to the town's regional line?
I'm not aware of that.
You're not aware of that? Okay. Thank you. Mr. Stangler, let's look at another document that was filed in federal court action. Let me ask you if you can identify this.
This appears to be an order from the DHEC board. In a case between DHEC and Carolina Water Service, dated 2004.
Have you ever seen that document before?
Yes, I believe I have.
You have, okay. And are you aware that that document affirmed the administrative law court order we just spoke of and said Carolina Water Service could not be penalized for not connecting the I-20 system to the town's regional facility?
I do not specifically recall that conclusion.
You don't?
I don't. You're asking me if I remember every. It's hard to keep track of all of the different court cases that I've reviewed that y'all have been part of.
Well, let me ask you this. What do you know about that order? You said you were familiar with it.
I do recall. I know I've looked at several of the administrative law cases. I believe this one did deal with the 208 plan and the efforts to eliminate the CWS I-20 discharge. I'd be happy to read it again if you want to point me to a specific section.
No, that won't. You've identified the document. That's all I would require. Thank you. Mr. Chairman, at this time, I would move into evidence as the next exhibit. A March 15, 2004 order of the Board of Health and Environmental Control. It bears the federal court entry number 16-3.
Microphone. Sorry.
We're going into tremendous detail about federal court actions, ALC actions, what this is DHEC board action. I don't see, most of these don't even involve the legal fees that are an issue in this case. So I don't, other than trying to show that Mr. Stangler's picking on the company somehow, I don't know where any of this is going. I believe it's irrelevant.
Mr. Chairman, it's completely irrelevant because the Office of Regulatory Staff has taken the position that the legal fees that had been sought shouldn't be allowed to be recovered. This witness is saying that Carolina Water Service filed unnecessary motions. It's necessary for the company to be able to demonstrate to the Commission the reasons why they filed those motions in federal court and the reasons why they took the litigation posture they did for the Commission to understand whether or not the fee was reasonable under the Glasscock and the Jackson v. Speed factors, which this Commission ordered in the order granting rehearing be examined. Notwithstanding that ORS really hasn't addressed that, Carolina Water Service does intend to follow the Commission's directive. That's why it's relevant.
Mr. Chairman, may I make a suggestion to council, and perhaps we could save some time, I don't know. You look like you've got a number of different documents that you want entered in the record. If you could go ahead and identify them, and perhaps we could enter them in the record. We won't have to go through each one.
Well, happily, Commissioner Irvin, some of them we may not. I see the stack, and I
see the big stack.
But some of them may not need to come in,
yeah.
And I'll try to go as quickly as I possibly can.
Thank you.
Thank you.
Okay, we still need to address.
If I could briefly respond, I understand where Mr. Hafer's going with this line, but I would point out, as I mentioned in our opening statement, we are not contesting the reasonableness of the amount of any of these bills. What we are contesting is whether or not these fees, these attorneys' fees, are properly placed on the backs of the ratepayers, as opposed to be something that should either be deferred for the time being until the case is concluded, or that it should be paid for by the shareholders. We don't question the reasonableness of these fees.
Well, Mr. Chairman, fortunately, ORS doesn't get to decide that. You decided that when you issued your order on rehearing. And I will tie it up all at the end in a nice, neat bow so everybody will understand why this is relevant. But they have talked excessively in their order about the federal court order. And what we need to demonstrate to the commission is the reasons why the company did, in fact, litigate these issues, did, in fact, file the motions that this witness has said were excessive, so the commission can understand the very question Commissioner Howard asked, how are the ratepayers benefiting? We'll demonstrate that at the end.
We'll overrule Mr. Nelson's objection, and we'll continue. We'll enter this document as hearing exhibit number 12. And I would also take note of Commissioner Irvin's suggestions.
Thank you, Mr. Chairman. And at this time, I would ask that the commission take notice of a February 25th, 2002 order of the South Carolina Administrative Law Court issued by Judge Anderson, Judge Ralph King Anderson III. And this order is specifically referenced in the exhibit that was just entered into evidence.
Okay, we will take notice.
Thank you, Mr. Chairman. You heard Mr. Gilroy testify earlier that the town didn't have treatment capacity to take flow from the I-20 plan in 1999.
Yes, I heard that.
Do you agree with that testimony?
I don't know that as a fact.
You don't?
I don't. Not.
Okay. You don't know whether or not the town
I don't know
had
what the
capacity in
town's
1999?
capacity was in 1999.
You don't know? Okay. All right.
You have a copy of the ALC?
Yes. How many would you like, Mr. Chairman?
Anybody else?
So, Mr. Stangler, coming back to the question I asked you don't know, let me show you this document and ask if you can identify it.
There appears to be some sort of agreement between the town of Lexington and DHEC.
Have you seen that document before?
I don't know that I have.
Does it bear the federal court legend?
It does.
And so this is one of the documents you may not have reviewed.
This may be one of the documents that I did not review.
Okay. Thank you. Beg chair's indulgence. Mr. Stangler, if DHEC and the town of Lexington agreed in 2000 that the town didn't have capacity to take the flow from the I-20 system, how could Carolina Water Service connect to the town's regional line?
I think that the federal court clearly said there were other opportunities. And again, we can go back and look at the order if you want. To do that after 2000, I don't know the exact timing of when more capacity became available in that system.
So again, your testimony is you don't know in the year 2000 whether or not the town, in fact, had capacity to take the I-20 flow.
I do not know that.
Okay, thank you. Mr. Chairman, at this time, I would ask the Commission to take notice of its order number 2003-10 in docket number 2002-147-S, January 7th, 2003.
Okay, we will take notice. Copy. Yeah.
Mr. Stangler, did you hear Mr. Gilroy testify about the company's attempt to have the Commission approve a wholesale service agreement with the town of Lexington?
I did hear that.
And you understand that that was denied by the Commission?
Yes.
let's go back to your testimony, if we could, page 2, lines 20 through 21, Mr. Stangler.
Yes.
And there you state, quote, "We monitor all sorts of sites in our watershed and take enforcement action when necessary." Is that correct?
Yes.
I'll come back to that when necessary part in a minute, but let me ask you, confirm, one way you do this monitoring is to review the DMRs, the discharge monitoring reports of permit holders?
That is correct.
Okay. And for this, well, not for this case, strike that. You have reviewed the 1997 Water Quality Management Plan adopted by the Central Midlands Council of Governments under Section 208 of the Clean Water Act, have you not?
The 208 plan, yes.
And that 208 plan covers the watershed that you monitor,
Yes, it does.
and it covers tributaries and rivers that are within your monitoring and advocacy scope. Is that correct?
Yes, it does.
Okay. Now, isn't the same connection requirement that CWS had for their I-20 facility applicable to the town's Coventry Woods wastewater treatment facility?
The town's Coventry Woods plant was also considered a temporary facility that was supposed to tie into the regional system.
Okay. And when was it supposed to tie in?
I believe it had a similar time frame. I don't know the exact date. And they tied in, I believe, October of 2015. They ended their discharge.
And so they had a similar time frame. By that, do you mean they had the same obligation to tie in or to connect in 1999 that CWS has?
I don't have their permit in front of me, so I can't speak
Okay.
to specifics, but I'm sure you have a copy.
Well, your certainty is going to be rewarded, sir. That's correct. Let me ask you if you can look at that and identify that for me.
This appears to be a 2000 MPDS permit for the town of Lexington's Coventry Woods wastewater treatment plant.
Have you ever seen that document before?
I have.
Okay.
I believe either this one or perhaps a different version of it. I don't know which years I reviewed. I've seen the Coventry Woods MPDS permits before.
And when you say different versions, is that because that permit was renewed and modified a number of times subsequent to the expiration date in 2002?
I say that because I don't know which ones I've actually looked at in the past. Permits are supposed to be reissued every 5 years, so when I had an intern compile all the permits, we had permits that went back several years.
Okay. Well, let me ask you, well, first, Mr. Chairman, I'd move as the next hearing exhibit the surface water discharge permit for the town of Lexington Coventry Woods wastewater treatment plant issued March 24, 2000. It bears the federal court entry number 81-11.
Mr. Nelson. The exhibit number 13.
Okay. Mr. Stangler, if I could get you to please go to page 5 of 20. I think it's 5. Let's see here. Yes, page 5 of 22. Do you have that?
The page that starts with groundwater requirements?
Yes, sir. And the next section is headed number D, Schedule of Compliance.
Yes.
Okay, and if you would, read for me out loud section D2A.
Yes. Right here. In accordance with the area-wide 208 Water Quality Management Plan, this facility is considered a temporary treatment facility that must be closed out. The department has determined that a regional sewer system is available, sewerage system is available. The permittee has until October 1, 2001 to cease discharge from this facility. See paragraph 1 above.
Okay, Mr. Stangler, you've already testified the town didn't cease their discharge until October 2015. Is that correct?
Yes.
So the town went more than a decade and a half without eliminating that discharge that they were obligated to eliminate. Is that true?
Yes.
Okay. Why didn't the Congaree Riverkeeper bring a citizen suit against the town?
We actually placed the town of Lexington. We published what we called the Dirty Half Dozen list, which was a list of the top 6 polluters that we were concerned about and issues that we were looking at. And the town of Lexington and their Coventry Woods facility was on that list. We drew public attention to that issue. And then DHEC actually issued administrative orders against the town. They had a compliance meeting. They were going to, I believe they were working to remedy issues with that facility. And through that process, we learned that there were efforts underway to eliminate that discharge in the near future.
Okay. Let me ask you this. When did the Congaree Riverkeeper send a notice of violation to, or 60-day notice, if you will, to Carolina Water Service?
I'm going to have to refer to my notes to remember the exact date on that, but I believe... Sorry, it's in here. I know it is. November 4th, 2013.
Okay. So in 2013, Congaree Riverkeeper had identified Carolina Water Service, sent them a 60-day notice. Had Congaree Riverkeeper in 2013, November 2013, had it identified that the town was in violation of its permit?
Yes.
But you didn't send the town a 60-day notice, did you?
We did not.
Okay. Let me ask you to go to
Nor did we send 60-day notices to a handful of other sewer facilities that may or may not have been in violation at the time.
Thank you. But is a reason why you didn't send one to the town is because they own the regional line?
No.
Okay. Let me ask you to go to page 3 of your testimony, lines 5 through 6.
Yes.
And you say there, quote, we would consider litigation against any other company doing the same thing. Is that correct?
That is correct.
Do you mean by that you would only consider litigation against a private entity when you use the word company?
I do not. I think
Okay.
a better term may have been entity.
Okay, thank you. Now you say it also at page 3, go to lines 7 through 10. You have that?
Yes.
You say that a key factor in the Congaree Riverkeeper's decision to bring the federal court action against CWS was the multiple effluent discharge violations CWS had. Is that correct?
Yes.
And I think we've already established the town of Lexington had multiple effluent violations during that period, did they not?
That is correct.
Okay. Now, you were in here and you heard Mr. Gilroy's testimony about the communications between your council and, Congaree Riverkeeper Incorporated's council and the town,
Yes.
right? Why wasn't that affidavit that was drafted and exchanged between Ms. Wanamaker and Mr. Black, why wasn't that filed in federal court?
I don't know what specifically that was referring to.
You don't know what the affidavit was referring to?
I don't know that affidavit off the top of my head.
Okay, well, let me show you this document and ask you if you can identify it.
This appears to be the same emails that were read earlier.
And this is an exhibit to Mr. Gilroy's testimony that's been entered into evidence in this case. Is that not correct?
I believe it is.
And you reviewed Mr. Gilroy's testimony, didn't you?
I did review.
Did you review these exhibits?
I am not going to claim that I reviewed every page or every piece of every bit of testimony.
And you didn't review this exhibit?
I have seen some of these emails, but no, I did not review all of this.
Okay. Did you review the affidavit?
No.
Okay, thank you.
Not.
Mr. Stanley, go to page 4, line 15 of your testimony. And am I not correct that you mentioned there that the Clean Water Act is a strict liability statute?
That is correct.
Is a violation of an NPDES permit a Clean Water Act violation, Mr. Stangler?
Yes, it is.
Okay. Now go on to page 8 of your testimony, if you would, sir. Have that. And at page 8 of your testimony, you mentioned 2 federal court decisions involving Clean Water Act violation cases.
Yes.
Did you review those cases before you filed your testimony in this case?
I'm somewhat familiar with those cases, but actually, that was the testimony was prepared with assistance from my attorneys, and so the citations to court cases were from the attorneys, and I can't speak to. While I know I've looked up Piney Run Press and Friends of the Earth cases before, I can't speak to them right off the top of my head.
Okay. Well, do you consider yourself knowledgeable generally about appellate court cases dealing with Clean Water Act violations?
I'd like to tell people that I'm not an attorney. I only get to play one on TV.
Okay. But you've cited some cases here in your testimony, correct?
Yes.
So I'll ask my question again. Are you generally knowledgeable about appellate court decisions in cases involving Clean Water Act violations arising out of NPDES violations?
No.
Okay. Are you familiar with any South Carolina cases dealing with the obligations of a designated management agency?
Off the top of my head, no.
Did you read the Carolina Water Service submissions in the federal court case, their memos?
You have to be a little more specific.
Did you read the memoranda submitted by Carolina Water Service in the federal court cases, in the federal court case, the memoranda they have submitted to the district court?
I've read some of them, yes.
Okay. Did you ask your attorneys to explain any of the case law in those memoranda?
Yes, we've discussed some of the underlying case law.
And was one of the cases you discussed City of Columbia versus Board of Health, which is reported at 355 Southeast 2nd, 536?
Yes.
You did discuss that case. So you're aware that in that case, the South Carolina Supreme Court held that the burden of making a connection to a regional facility is on the designated management agency.
I am aware of that.
Okay. And did you also discuss the case of Midlands Utility versus DHEC reported at 437 Southeast 2nd, 120?
I do not recall that one.
You don't recall that case?
I don't.
Well, let me ask you, do you recall reading a case where the South Carolina Court of Appeals found that a utility, in fact, Midlands Utility, could not be penalized for violating the permit limits when the City of Columbia would not give them a connection?
I do not recall that.
Okay. Go to page 6, line 16 of your testimony, please. And I think you state there that CWS had the ability to resolve the connection issue.
What would you like me to do?
Page 6, line 16.
Yes. Do you want me to read it?
No, I'm just asking you. You're saying there that CWS did have the ability to resolve the connection issue. Isn't that what you're saying?
Yes.
Okay. All right. What action should they have taken to resolve the connection issue?
The contention there is that CWS only acted to resolve this issue on their terms and not terms that weren't necessarily favorable to the company. So it seems that there would have been other ways to do it that may not have been as financially lucrative to the company.
Well, let's explore that for a minute, Mr. Stangler. You do acknowledge, do you not, that the town of Lexington refused to offer a wholesale service connection?
I believe that is the case.
And you understand that the town of Lexington took the position in November of 2015 at a meeting organized by the Office of Regulatory Staff, disclosed to Carolina Water Service that they were legally precluded from giving wholesale service to Carolina Water Service?
Yes.
And that was because the town of Lexington had entered into a 2009 contract with the city of Casey, which precluded providing wholesale service to private utilities?
Yes.
And that's also because the town of Lexington had issued bonds to finance the capacity it was purchasing in the Casey treatment plant, and those bonds had covenants that prohibited the town of Lexington from offering wholesale service to a private utility?
After 2009.
Correct. You do understand that. Okay. All right. So, what could Carolina Water Service have done since we've established that the town couldn't give them and wouldn't give them wholesale service? What should Carolina Water Service have done to make the connection from that point forward?
So actually, the issue was not necessarily a connection, but an elimination of the discharge to the Saluda River. And there are a handful of potential ways that could be done. Certainly, sale of the facility, condemnation, friendly or otherwise, are options to do that. There are perhaps less feasible but still potentially possible opportunities. Pump and haul. rather than discharging the waste to the Saluda River, they could pump it from the lagoon and haul it to an approved treatment facility that would give them a rate. And I'm sure there are other possibilities as well.
Do you know of any approved treatment facilities that would take pump and haul in that capacity?
I don't know. I do not know.
I'm asking you,
I do not. I've not investigated that.
You do not know of any?
I'm not responsible for providing that service.
I understand that. I'm just asking if you know.
I'm not aware of any.
Okay, thank you. Do you think the town negotiated in good faith with CWS?
I can't speak to that.
Okay. Now, again, we've established you reviewed some of the documents filed in federal court. Did you happen to review the affidavits of Mr. Gilroy and Mr. Durham on behalf of Carolina Water Service filed in federal court?
I'm sure I did at one point. It would likely have been several years ago.
Okay. And you read in Mr. Gilroy's testimony in this case where he described communications he had with Mr. Alan Lutz of the town of Lexington?
I don't recall that specifically.
Okay. Let me ask you if you take a look at that document and tell me what that is.
This appears to be an email between Bob Gilroy and Alan from the town of Lexington.
Okay. And this was an exhibit to Mr. Gilroy's testimony in this case. Did you review his exhibit?
Yeah, I did not get to review all of the exhibits, so I can't say that I saw this one.
Okay. Thank you. Mr. Stangler, page 5, lines 11 through 13 of your testimony, you state that, quote, Congaree Riverkeeper spent huge amounts of time dealing with all of CWS's motions in this litigation, which unquestionably made the attorney's fees for both sides much higher than necessary. Is that correct?
Yes.
It's fair to say you think CWS filed too many motions in the federal court case?
Yes.
Okay. What's your base of knowledge with respect to the appropriate number of motions filed in a federal court action?
It is a personal opinion of mine.
Okay. If CWS wanted to avoid filing motions and the town was unwilling or unable to provide wholesale service, what was it that CWS should have done in order to avoid filing those motions?
Motions that included attempts to stay the case and motions that attempted to dismiss the case for standing, we could have let the case proceed.
No, I'm asking a different question.
Okay.
If they wanted to reduce the number of motions that they were filing and the town would not give them a wholesale connection, what could Carolina Water Service done with respect to the town?
I presume you could have made them other offers to eliminate the discharge.
Okay.
Mr. Hayford, let me ask you real quick. We're kind of looking for that little bow that you were talking about earlier.
It's coming, Mr. Chairman, and it won't be long.
Won't be long?
Won't be long.
Okay.
Now, I'll qualify that by saying it's sort of like Mr. Elliott's brief.
Oh, well, that's not
quite,
any good.
It's not quite that bad.
Okay. We got another 10 minutes before Ms. Wheat needs a break, so.
Thank you, Mr. Chairman. Mr. Stangler, page 7, lines 17 through 19 of your testimony.
Can you repeat those numbers?
Page 7, lines 17 through 19.
Yes.
You state CWS had time during this period to try and resolve the situation, but no resolution was reached. Is that correct?
Yes.
During that period, isn't it true that the town refused to offer wholesale service?
I guess so.
And isn't it also true that the town never offered to purchase the CWS system? during that period?
I'm not familiar with all of the negotiations that you had with the town.
Are you aware of any offer that was made by the town of Lexington to purchase the I-20 system?
Of any offer?
Yes.
During that time period or otherwise?
Otherwise, or during that time period.
I believe the town did make an offer to purchase the system. I don't know the exact date.
Was it after the federal court issued its order imposing a $1.5 million penalty on CWS?
I believe that is correct.
Okay. And how much was that offer for, if you know?
I do not know off the top of my head.
Okay. Mr. Chairman, if you'll indulge me, I'm going to try to cut some things out.
Good plan.
Go to page 8 of your testimony, Mr. Stangler.
All right.
And line 16, I think you asked this rhetorical question, correct me if I'm wrong. Why would a utility ever voluntarily come into compliance if it could choose instead to refuse to comply, litigate for years, and then recover the cost of litigation from consumers if it did not prevail?
Yes, I asked that rhetorical question.
Okay. Let me ask you this question, Mr. Stangler. If a designated management agency obligated to eliminate a discharge under a 208 plan has no obligation to provide wholesale service and can make a low or even no offer to purchase a private utility system, knowing that penalties are going to be imposed on that utility system that does not accept its offer, why would a designated management agency ever offer fair compensation for that utility system?
I don't know the answer to that question.
Okay, thank you. We've already covered this, I think, but just to reconfirm, you were present on November 17, 2016 in the motions for summary judgment in federal court.
Yes.
All right.
Now you're repeating yourself. You've asked that question. It's been answered. I think we're losing patience with you, counsel. We've tried to be patient. We really have.
I'm about to conclude, Your Honor.
Thank you.
Thank you. Hand you this document, please, sir. Ask you to turn to page 25.
Like me to identify the document?
Well, I'm going to ask you some questions about it. It'll go quickly, I promise. Now, excuse me, I'm sorry, page 51, I apologize.
I would like somebody to identify what this document is. I don't even
Certainly.
talk.
And Mr. Stangler, this is a transcript of that hearing in federal court, is it not?
Well, I believe it is.
Okay. And I ask you to go to page 51, line 25.
Okay.
And the person identified there, Mr. Holman, is that the Congaree Riverkeeper attorney, James Blanding Holman IV?
Yes.
Okay. Let me ask you to go to page 55.
Give me paper cuts.
And if you would, come to line 6.
Okay.
And if you would, I'd like you to read aloud to the commission, starting on line 6, and read it through line 16.
CWS did not deny that this court could order shutdown. You asked the question, and the answer was that would be a something man. That would be, nobody wants to see that. It's an environmental problem. That is a practical problem. It would open up CWS for liability. Your Honor, shutdown of a facility that is not complying with the Clean Water Act is relief that we sought. It is relief that is appropriately considered and should be considered at the appropriate time. No one wants to create a public health emergency, but we do need to stop the environmental degradation that's happening.
Mr. Stanley, your testimony that the Congaree Riverkeeper never asked for termination of service of the CWS customers in federal court is not true, is it?
to stop CWS from providing sewer service to their customer is certainly different than allowing the company to continue discharging into the river illegally, in my opinion.
Was Mr. Holman your attorney in this case?
Yes.
Was he authorized to make this statement to the court?
Yes.
Did he not say that shutdown of a facility is not complying with the Clean Water Act is relief that we sought?
He said that, yes.
Okay. Thank you. No further questions, Mr. Chairman.
Thank you. We're going to take a break for 10 minutes.